Very warm welcome to everyone, and especially our guest speakers today, who are seasoned GCs. And we are very lucky to have such a depth of experienced general counsels with us. Having been in a GC myself, the kind of breadth and depth of experience you get dealing with legal issues in India, especially in the kind of companies that both of them have worked in and across various sectors, between both of them, they are covering pretty much all the important sectors in the country they have already dealt with, whether it's cement, whether it's IT, whether it's manufacturing, whether it's real estate. And I believe Rajiv was also in a PSU, many years ago. So that kind of depth of experience, I think, is very important for the kind of topic that we are dealing with. And the purpose of doing the webinar today was really, while the government is very rightfully focused on decriminalization of economic offences and has come out the specifically the Ministry of Finance has come out with two circulars just recently in June 2020 itself, proposing amendment of they call it the circular as decriminalization of minor offences, but includes some of the important legislations with respect to where they're looking to make amendments, and it is, I think, a step in the right direction. Before this, the same minister is also responsible for Ministry of Corporate Affairs, and they had also looked at amendments in the Companies Act. So with this, there seems to be a clear intention in this administration to understand, the business difficulties that the businesses in India are facing with respect to criminalization of certain basic offences, which is not really inducive to doing business in India. So with that in mind, we were hoping that this discussion will help us think through, in addition to what they have already suggested, what else do we need to include here? And of course, also discuss on what has been included, whether that makes sense. So with that, let me just dig right in. Manish, let me first ask you, if you think the list covers everything that really troubles you in terms of doing business for your companies, and what's been included, does that make sense?
Okay, thank you for giving us an opportunity, and thank you for a very generous introduction. Take it with a pinch of salt. I wrote that for her. So it's never enough. This is the first part. Could have been done more? The answer is yes. Is it a good beginning? The answer is yes. Now, has everything that has been included is good? The answer is no. The notable exception could have been a Negotiable Instruments Act, the amendments which have been made there. I will make a statement, and you see how do you find the statement. The statement is that the businessmen, and so far as the business community is concerned, they should never be punished criminally. They should not be put behind the bars. That does not serve the society. Rather, they should be economically punished. If I make this kind of a statement, you would say that this is a liberal, laissez-faire kind of a statement, and therefore that government is the best that governs the least and leaves the businessmen to do what they have to ought to do. But this genesis of this statement, depending upon, is not of a recent origin. It is not even of the origin of the 18th or the 19th or the 17th or even the 20th century. This statement comes from Mahabharata. So when Bhisham Pitama was put on the sleigh of arrows, and there was still time, Yudhishthira wanted to learn something and wanted the Pandavas to learn something from them. So it is insofar as the Shanti Parv, that part of the Mahabharata, provides, and in one of the lessons or the political teachings, what was given to Yudhishthir was that the businessman should not be, or the business or the commerce, the businessman would not, they should not be put behind the bars. Rather, an economic thing should be inflicted. So therefore, probably with the advent of British, they thought that we could only be chastised by putting the fear of putting behind the bars. So I think this is a very good step, and the manner in which the government of India has taken this step, what has prompted them, maybe the pandemic. There cannot be a direct correlation with pandemic and the liberalization of these laws and things of that nature. Be it as it may, the rationale may be any. The intention seems to be good. Nobody should be sent behind the bar for trivial, tittle, tattle reasons. If you were to do that, you would spike the businessman. You would put not the fear of God, but the fear of the government, fear of the inspector in him. And therefore, all procedural lapses, all small lapses, all lapses which can better be ignored, should not be punished. This is certainly, we are certainly not living in a police state. We became independent in 1947. But what we find that every legislation which was made thereafter, at the end had a small clause which said that if you do not do X, Y, Z, you would go behind the bars. And ultimately, if in case of a corporation, the directors, unless otherwise they were able to prove that they did or did not participate in that act, very well, the government will look at the website and the inspector will go and issue a notice to all. So therefore, what has been included is welcome, except I would say insofar as the Negotiable Instruments Act is concerned. When I look at the Negotiable Instruments Act, I was discussing with Pratibha, I was trying to find out what is the logic and the reason. What is the agistum generis which puts Negotiable Instruments Act in that kind of a company of those August, if you look at those criminal offences, in most of the cases, you will find that the action would be taken by the state if there is an infringement. But the negotiable instrument act is only exception, a quasi-criminal offence under 138, where a private party can initiate he is the complainant. It is not state versus so and so. It is XYZ private limited versus XYZ, and so on and so forth. So what I looked at is I looked at the Law Commission report, and it says there's a 213th Law Commission report. The Law Commission report talked about the fact that some method to the madness must be brought in. There are around about 40 lakh odd cases which are pending in different courts, and they consume the time of the court, and financial discipline to bring about, and ways and means were suggested.
So Manish, sorry, just for the purposes of the audience, we're talking about the legislation dealing with bouncing of checks.
Bouncing of checks. So insofar as the bouncing of checks were there, certain amendments were brought in 2018. I saw that on 5th 2020, there was an order by Chief Justice Bobde where he took it up. The matter was taken up, and it was said that it was a suo motu matter taken up, and there the order was passed that insofar as 40 odd lakh cases are pending, out of which 18 lakh cases are those in which if the service has not been complete, they have choked the entire system, and a notice was issued to the central government, the state government, the RBI, and the IBA, and all other interested parties were issued notice, and something needs to be done, and everybody was asked to file an affidavit. So by this one stroke, what the government wants to do is, it looks like it is asking for the suggestion that since we cannot handle 40 lakh cases which have choked the entire criminal system, and there was some report also which said that 70,000 cases by some telecom companies were filed in a single day in Gujarat. And therefore, something needs to be done. The best way to deal with 50% of the cases which are there in most of the metropolitan or the metros are concerned is to do with of this act itself. Now, this I have an objection to, because Negotiable Instrument Act, the entire credit system of the market will go if they were to make this one offence, which is a criminal or a quasi-criminal offence, into a civil offence. It will not reduce the burdens, because all those checks, people who have issued the checks, they would go ahead and file civil courts. So instead of criminal courts, the civil courts will be full with all these petty matters. Now, at the time of summons or otherwise, some kind of a settlement takes place and things to happen. There is a fear of God and a fear of going to jail for those people who have availed goods and services or loans and have given an instrument, a negotiable instrument, which at the end of the day, if it is not honored, they would go to jail. So I have a serious reservation with respect to, in the absence of any other system by which the private parties, the money which is to be paid and it can be honored, in the absence of a viable kind of a system. I think this was people were very lenient in giving. If the credit and the system dries up in the market, it will adversely impact. I have a large list of exclusions. Probably now, or Pratibha, you want me to count them now or later?
We can come back to it. I
Okay.
think what you're stating, just for the purposes of the audience, for dishonoring of checks being decriminalized as an offense, you think that it works as a deterrent currently in the market until till the credit system is improved, where you have more online transactions and a better support. Which you're right. Even for our corporate transactions, we take sometimes checks, as
Yes.
guarantee. So in light of that, whereas as a group of lawyers, we are supportive of decriminalization. This is one where we think that actually, for smooth functioning of credit, the deterrence here at least works. Rajiv, let me
So,
just
so
quickly. Manish, go ahead.
one more point. So they must find solutions, ways and means as to how they should address this problem, where the entire criminal system, the courts have been choked. I was also trying to find out the figures, but no statistics are available. 1,200 to 1,400 to 2,000 crores is the figures which come out, is the money which is recoverable by way of these checks, for which various proceedings have taken place. If this fear was to remove, then the bad debts will become 10 times or 20 times of this. Now, insofar as this 2,000 crores is concerned, which is to be recovered, even if they were to put up fees of say 10%, 20%, or 30% amount, they can have special courts which can be self-financing, would bring some madness to this method to the madness, and this problem can be dealt with. It cannot be dealt with by shortening the process or killing this entire system which has been created. But yes, it should not be that you pay a paltry court fees of 1 rupees 25 paisa, or now maybe 1,000 rupees, and then the judicial system is taken to ransom. They must find a commercial solution to the commercial courts, like you have commercial courts. Like, some solution needs to be turned out where the accused or the complainant, as the case may be, pays for this services, and it is not done at the cost of the exchequer and free and at the cost of other litigants. That's the solution, and I will come to the other acts little later. Thank you.
That is a very interesting solution, just not being done in India. It's there in other jurisdictions that we just have, especially because private parties, this is not like any other criminal offense, right? This is something where private parties can go against other private parties. Rajiv, I think the most important issue here is what else is required on the list. I think between you and Manish, there's a lot of knowledge in terms of what really is businesses, especially MNCs, who just follow the spirit and the letter of law, um, and then find it very, very difficult to navigate in India. We talked about, for example, I think pretty much every FMCG company I can think of, any GC will talk to me about legal metrology, for example.
Absolutely. So I think first of all, I cannot agree more on the previous point, which before going on onto the legal metrology, I cannot agree more than what Manish has said. That there was a purpose why there was an amendment done in the Negotiable Instrument Act to make bouncing of check as a criminal offense, because checks as a matter of routine were being issued and were not being honored. So to basically to to just to stress the credit, even today with despite the fact that 138 is a criminal offense, still people issue checks and they know that I have an option to settle it before it touches, the water goes beyond my level. I have an option before the magistrate also. So people are so notorious. So I think as a country, like in terms of ease of doing business, we have a big issue in terms of honoring of contracts. I think credit discipline is something which, so I think if the government is thinking, as the points which Manish raised are very valid points, that while you are trying to address one problem, you are creating another set of problem. Because if I do not recover under the 138 mode, I will have to go and file a civil suit. Because ultimately you are shifting the problem from one place and putting into another basket. Now coming back to the point on the Legal Metrology Act, here is an act which has not one but multiple provisions where it says that at the second instance, if you default in terms of complying to any small rules on regulation in terms of the disclosure in the packaging, or if you have printed and something is missing, you will be liable for imprisonment of term which ranging from 6 months to a year. And just think of a company, as you mentioned, FMCG, which has a pan-India presence. Even we are into cement, we are into pan-India operations. We are almost present in all the states. And yeah, there are millions and millions of cement bags which are moving from left, right, and center, and it is getting handled. Cement being a bulk commodity, there are a lot of mishandling when it is getting transported by railway rakes and even by trucks, loading, unloading. So there are possibility that something while the entire printing is technology driven, and there is no intent for the company not to comply with the standard weights and measures, which is basic the Legal Metrology Act. But I'll give you a classical example, my own example, that we came with a new scheme where we decided to give a fixed price, announce a price which is going to be valid for say 1 year, and we because in cement what happens, or any commodity, the price keeps on changing basis your cost of production and other factors. And so we wanted to give it was all for the benefit of the consumer, that here is a product where I am telling that this is the price, and the price is not going to change next 1 year. So you can plan if you are an individual home buyer, you can plan your construction cost, the cement cost, so that otherwise what happens, you plan that today cement is 300 rupees, and tomorrow the price may increase to 320 or 310, and it actually disturbs your own budget. So we gave a newspaper advertisement saying that this is the product, this is the price, and somewhere the marketing guys missed mentioning that this price is for a 50 kg bag. Now, technically, if you see, and this is not on the bag, this is on the newspaper advertisement, which is given in say Dainik Jagran or any other newspaper. And I start receiving notices for prosecution in the name of all the members of the board of directors, including my member group CEO who is based out of Switzerland, that there is a prosecution against you, despite the fact that one of the director is nominated as the responsible director. Generally, it's the CEO. And just imagine one district after another district receiving notices, although there is an option of compounding. But just understand that this is for one particular state. If this is to happen across India, the GC will have no other work but run after compounding. So I think these are very draconian laws as far as criminality is concerned, because I don't think any company, good company which has system processes and which is always on the right side of law would like to breach any law. But if by mistake or for whatever reasons, if there is anything which is missing, I think the criminalization has to go. And if we really want to, attract investment and make India as an investment destination, this will go a long way. It's not that people today are not investing, but then there are many investors, many companies looking at the legal system and process which is there. It becomes very difficult. Some of the examples I would like to also touch upon, apart from legal metrology, in terms of criminal prosecution, is one of the classical case where, in the 2G case, Mr. Sunil Bharti Mittal was, the CBI was trying to summon him, saying that he is the alter ego, and finally, Supreme Court, the matter reached Supreme Court, and I think this is one of the judgment which is extensively relied, which GCs rely on, as far as because in that case the company was not made a party, I think, as far as I remember. So if an entrepreneur who has established a enterprise as big as Bharti Airtel, and if I go back to the statement which the Prime Minister made on the last Independence Day, that wealth creators has to be honored. I think any entrepreneur or any promoter who has started an enterprise, he takes all the risk, he puts all the capital, he generates all the revenue for the government, he generates employment for the people, and the entire business cycle. Rather than rewarding him, if the government of the day, whichever government is there, if they want to prosecute, I think it's very unfortunate. I think, as a matter of rule, unless there is an element of fraud or mens rea, or there is an intent to kind of cheat, there should not be criminal prosecution. Is what I would like to briefly say, and then as the discussion goes on, we can catch upon. So legal metrology, and definitely most of my professional friends will agree, and it is actually not serving the purpose, and it is just like we are creating work for the legal metrology department.
Thank you, Rajiv. Actually, I would completely agree that somewhere, the whole concept of the two basic tenets of a criminal, for it to be a criminal act of mens rea and actus reus, are just missing. Not just the small offenses, but like you mentioned, for example, on 2G, I can give you so many examples of cases that we are dealing with, where there will be the current board of the accused company being named, and that those board members were not even there when the alleged action happened. So, and this is not even under a statutory provision. You're going under 420 of IPC, and there again, mens rea becomes extremely critical. But when we go and argue to the officials, despite showing the jurisprudence in India, their argument back is that if you don't name the current directors, the company doesn't have a natural person, is not a natural person. So we have no choice but to go after the current board of directors. Now, how do you, so by the time you already have an FIR against your managing director, who's, somebody as prestigious as Mr. Mittal, who's done so much service to the country in terms of wealth creation, or, the global or the regional CEO of Samsung, for an example. Now, how do we actually so one thing is decriminalization of the existing statutes. But Manish, let me just bring you into this discussion, and you should also talk about your extension to the list. But I know how strong your legal jurisprudence inquisitiveness and knowledge is. You started the discussion with not just Western jurisprudence, but going back to the Eastern jurisprudence of Mahabharata. Um, how do we deal with this situation? Like practically, if we have to tell the government, what are we going to? How do we go back to at least some semblance of having some major uh, checks and balances before even an FIR is issued? Sorry, you're on mute.
Okay. Okay, can I be heard?
Yes.
Okay. So one is an anecdote. In general, in small city courts, in small cities, it said that Diwani or Faujdari, दो तरीके के केस होते हैं, that is civil and criminal. Diwani is civil and Faujdari is. So one person went and said that कि मुझे पैसे recover करने हैं. कहते हैं दीवानी करोगे तो दीवाने हो जाओगे, फौजदारी करो बिल्कुल दौड़ते हुए आएंगे. So if you go to small cities, तो वो मतलब दीवानी जो है वो दीवाने हो जाओगे, वो मतलब एक generation. The case which I was referring to for the check bouncing case that came to the Supreme, the check bouncing cases were, when they were introduced, they were to be settled within a period of 6 months. After 15 years, the matter went to the Supreme Court, and that is how the suo motu notices were issued. And so if you look at it, the manner in which our civil jurisdiction system, like even if you look at the arbitration, it used to be 12 months. Now they say that it is going to be 18 months. The constitution was written in less than 3 years. They can't do the arbitration within a period of 12 months. I have my reservation. So therefore, वो दीवानी करोगे तो दीवाने हो जाओगे, and it takes so many years. You file an FIR, and if it is a small amount, and if I were to plead any of the big names and the 70-80 billionaires who are there, the person will go and settle it, and they will say that sir, जो देने थे ये लेने थे वो थे. So this is how the system has collapsed. So basically, there are scores of judgment. The problem which has happened is that for every one proposition, there are two propositions on either side. So whether the dispute is a civil dispute or a criminal dispute, they are unable to make up their mind. You file a criminal complaint, the person will come and settle. Otherwise, he will get harassed. And you make the entire board responsible and leave it. And ultimately, as you said, that in criminal law, there is actus rea, mens rea, and that must result into a forbidden consequence. All these three things must be present. So what has happened in most of the offences, as if the strict liability offences were an exception, now they have become a rule. If you don't do this, you go to jail. If you have not maintained a register, then we will issue you notices. If the register is not in the physical format and it is in the electronic format, then you will go to jail. We will issue you a notice, go to the court and explain what has happened. If you say no, the law has now changed, and he says go and explain before the magistrate that the law has changed, I am filing a case. So the system is so very unfair, and so far the police powers are so great, and you can put the liberty of a person that even Mr. Chidambaram has to run pillar to post from Supreme Court to High Court to the lower court to the various other courts in order to get a bail. See what is going to be the plight of a common man. So punishment rarely happens, but this process itself is a huge big punishment. So therefore, insofar as otherwise, if you go to the High Court, it depends upon the kind of a breakfast the judge has had. He can either come, why should I entertain the matter, go through the trial, trial is not a punishment. Or he will say that on the face of it, it is bad. In 482, I will quash it. So it's become so very topsy-turvy, that is that the propositions are so many and so wide that the judge sitting on there, depending upon the mood and the breakfast he has had, he can either throw your case by citing two cases or give you a relief. So that kind of a gamble which takes place in the high courts as a result of, and as a and which these criminal complaints cause is a havoc. So even if there are so many cases, if the dispute is a commercial in nature and out of an agreement, then therefore the courts ordinarily should not entertain a criminal complaint on the same. There are 50 judgments, but when you go to the court, you say, how do I know? Face the trial. As a result of which you will settle. So the settling of the scores become very easy. And insofar as today, what to say, the concept of alter ego, the basic principle of till IPC, when it was introduced, it was fine. There is no concept of vicarious liability in IPC. They are sworn enemies. You cannot be vicariously liable. It is more than 150 years that IPC is there. Still, you had the case of Mr. Sunil Bharti Mittal and the concept of alter ego. So, law is one thing, practice is another thing. You can still defame a person who has done so much good to the country, so much. And I'm saying so with take it with a pinch of not pinch of salt, but he has paid my check for 10 years. I feel so sorry if we had to go through this entire process, and it can happen to anybody. He had the money, he had done nothing, he could go through that process for 10 years, suffer. And for a common man, I think the criminal system, that is why they were saying that 50% of the matters of the courts are consumed by the 138 matters. This is COVID is a good opportunity in the name of it. Through this proposition itself, 50% of the cases will go. If they will not become criminal, they will go to civil. Again, diwani mein diwane ho jaoge, as a result of which the entire system will collapse. So this is a good opportunity.
Why would that argument not be applicable with respect to other economic offences? So one argument in favor of keeping criminality with respect to some of these provisions is the fact that you don't have an alternative in India, because the civil offences don't have teeth in the Indian context, because you can drag on matters for years, for example, right? And that's why you need to have the criminal aspect to get parties to, in case of government, to follow the law, in case of private parties, like you said, to settle. And that is, I think, the mindset with which some of these provisions have been put into law. So how do we convince our government that that in itself is not a good enough reason why you need the criminality for some of these economic offenses?
So I'll give you an example. The best example which is available is FEMA. After FERA became FEMA, today while we are sitting with the GDP zero or less than zero, which is predicted, our foreign reserves have touched $500 billion. Right. So therefore, therefore, by beating the child, as I was giving an example, spare the rod and spoil the child. So if you were to spare the rod, it is not necessarily the children today are far more brighter than my generation. They have never been touched. Forget about beaten. So that colonial mindset of putting person behind and take away his liberty and his everywhere. I will give you another example of advertising which happens in the whole of the country. Municipal corporations put one residuary clause. The advertisement is a subject which comes to the municipal corporation. There is not one billionaire or a CEO worth his name in this country who do a B2C business and has put an advertisement and not received a notice that if you don't deposit the money, we will send your CEO to jail. If it is not there, kindly do a Google search and kindly have a look at it. The number of cases which have been issued at one place or the other, and this municipal corporations which have that residuary power of sending you to jail for 6 months. As I was giving you an example, if you have a dog and you have not registered it and you have renewed it year after year, and you have not put that triangular badge or a circular badge which is issued by the municipal corporation, you along with the dog can go to jail. So they want to address everything by a criminality. As I said, trivial, tittle, tattle matters. Please impose a fine and move ahead. Look at stamp duty. Insofar as I was giving you another example, you receive the ticket, that revenue stamp, if you forget to put it and cross it, you can go to jail. Criminal prosecution can be started against you for not having crossed that stamp, because you will use it again and cause loss to the revenue. And now for every, I was giving an example, to put a 50 rupees stamp paper on an agreement, I send a person to Delhi, he goes and buys it, comes back, prints it, comes fine or not, goes and notarizes it. 1,000 rupees is the cost for that 50 rupees, out of which only 5 rupees may go to the exchequer. Look at the man hours that we have lost. And if I forget to do it, either it cannot be produced in evidence, or I have defrauded the stamp duty authorities, and therefore I can be prosecuted under the section 62 as I was showing to you. So whether it is a lease or a license, and if I pay 100 rupees or I have not paid the lease stamp duty, he will come and say that, okay, you have defrauded it. My friend has been dealing in mining leases, which may have been in the nature of licenses and things of that nature. You put stamp duty on there, start prosecution. So I think for everything, for a very small little offense, if you put everybody into jail, now if you look at what has happened, poor migrant laborers who started walking towards their villages, they have flouted the lockdown order, and criminal offenses have been issued against them. They will take it back. But look at the tragedy what we do. If you have given your premises on rent and have not registered with the local police station, there is an order under which you can go to jail. So everything has become criminal.
That is so true. But to me, the stamp duty one was also very, very surprising, because that is as economic an issue as it gets. It's just a collection of revenue for the state. And as you mentioned, it's the only consequence of not paying stamp duty is it's not admissible for you for purposes of for evidence in a future litigation. Why that would then require criminal proceeding against you? I was quite surprised when you pointed that out to me.
No, I have received a notice in my personal name. That's therefore I can never forget it. It's 62, but the fine is only 500 rupees. And but still, if you look at, I will have to go and take a bail, go through that entire process. So we challenged it in 482 in the High Court. How many people can afford 482? So ultimately, you will have to pay. So these small offenses, you are collecting 5 rupees, 10 rupees, 100 rupees, 50 rupees stamp paper. Look at the kind of wastage of time which causes. I can understand if there is an ad valorem stamp duty, you go ahead and collect it. I understand in a city like Delhi, if you look at the Delhi government's budget, out of which a large portion, out of the 50,000 crores, 7,000 crores comes from stamp duty. But this would have been subsumed in the GST. And look at the kind of havoc that we cause just because of 5 rupees stamp paper, 100 rupees stamp paper is not there. And ultimately, the matter has to go right up to the Supreme Court, and a judgment comes that if it is not properly stamped, then arbitration proceedings can be ensued. And in some states, if you go for that adjudication of that 100 rupees stamp paper, it will take 2.5 years. Whereas arbitration is to be completed within 1 year and now 18 months. So these small things like 100 rupees of stamp paper, it is an eye opener if you read that case.
Absolutely. So let's just talk about in the circular itself, the government has mentioned that one of the reasons for undertaking this measure is to promote investment in the country, because this does act as a deterrent for investors when you have too many criminal matters. But I think what the naysayers per se will say is, what is the big deal? If you have not done anything wrong, you just go to court. The court will figure out the nature of the offense, and it shouldn't be a big deal. But Rajiv, just help us understand. The GC understands really, what sort of deterrence in terms of the kind of corruption that has grown in the country as a result of some of these provisions. The kind of cost to a company that has very strict rules against corruption would have to deal with in such a scenario, versus that doesn't care about it much. I think some practical examples of what sort of issues this can cause, whether personal or from the market, that would be really helpful.
Yeah, in fact, I just forgot to mention that whatever I am saying are all my personal views and not necessarily the views of the organization.
Absolutely. And
That's
cCep
a
rules apply, no publishing any statements till we
no,
get
no, no,
confirmation.
just a safe harbor. Now, coming back, I will touch upon the corruption issue because one is that ACC is a very, current organization. It is a 84-year-old company, and it was always a professionally managed. There was never a promoter in this company. Although Tata's had some 14% stake, they sold it long back to Holcim, which is, and we are subject to, a strict ABCD, we call it anti-bribery and corruption directive. Even the CEO doesn't have any power to even approve any kind of facilitation payment. And in a kind of regulated industry where you require various license permits, and the board wants everything to be compliant, and the GC has to give a confirmation that yes, we are compliant. So it becomes extremely challenging. In fact, if you see, there is so much of contradiction in what the governments of the day do. Most of the state governments, they go abroad, and even in India they organize big investor meets. They will sign MOUs of 1,000 crores. I don't know how much of it actually translate into real investment, but they want investment in their state because you see one lockdown of 3 months. I would say not even 3 months. Effectively, it was for a month, at least for some of the process industry like us. And the revenue of the government of the day, whether it is the central government or the state government, is not there. They don't have money to pay even salaries. Some of the states have announced that we will defer the payment of salaries. So where is the flow coming from? Today, major investment is from the private sector, and you want investment to come, but you don't want to do anything. Ease of doing business has been talked about. Our ranking has improved, but I think it is more of marketing rather than things on the ground. While central government has done a lot of things, I would say in a positive way, things are not getting translated at the state government level. Now, I am a company who operate out of all the states, be it Karnataka, Tamil Nadu, Chhattisgarh, you name a state, we are present. And we have to deal with different, regulators in every state. So, simple things like you need a consent to, operate. So you first, when you put up an industry, you take an environment clearance, then you get a consent to establish, and then a consent to operate under the Water Act and the Air Pollution Control Act and those ancillary laws. Now that consent to operate is granted for 12 months. And it says that before 2 months before the expiry of the consent, you have to make an application and you have to pay the fee. So what do I do? It is going to expire on 31st March. My environment department makes an application in January, pays the fee. What does the pollution control board does? It sits on it. Why? They expect, I'm very sorry today, I'm not taking any names. They expect आप आइए और फाइल पे वजन रखिए. You understand, it's very famous कि without putting paperweight on the paper will fly. Why can't we have a consent to operate? And this is the view expressed by none other than Mr. Justice Swatantra Kumar, who was the chairman of NGT. I was present in NGT in one of the environment matters where he said that why are the consents being issued for 1 year? Why not 5 years? Now, if you give me for 5 years, it is not that if I am not, meeting the standards of emission, you have the power to issue a show cause notice, do a hearing, and take whatever action you want to take. But the whole system is, the entire system is so corrupt. The money goes up to the level of the ministers. So, every consent which has to be renewed means, and the bigger the player, the bigger is the demand. This is the unfortunate part of this country, and none of the state governments are ready to address. And I think we have these, the three C's, the CBI, the CAG, and the third one I'm missing, because of which today no bureaucrats wants to take decision. I'll give you a classical case which is in public information. there is a company called Hindustan Zinc, right? It was divested in the year 2002. At that point of time, Sterlite Industry, which is now the current day Vedanta, there was a bid system in which Aditya Birla, Sterlite, and many even companies outside India, they participated in that divestment process. The bid of Sterlite was found to be the best, and the share transfer was done, and the Vedanta, Sterlite got the control initially 25%, 26%, and then they made an open offer and they got it. After this was, I think, somewhere in 2014 when I was still in Vedanta. So after almost 12 years, CBI registers a preliminary inquiry of divestment of Hindustan Zinc against Anil Agarwal, chairman of Vedanta Group, and unknown officers of the government. Right? I think this is more to do with the way things move. A company which has been divested, which is a classical case of a success story. This company has paid, I think, I don't have the figures, but thousands of crore in the form of dividend to the government of India, because government of India still holds, I think, 26% in Hindustan Zinc. The market cap of Hindustan Zinc is almost 70 to 80,000 crore. Even Vedanta's market cap is not that much. A company in which it holds, I am discussing this case as a classical case that how criminal prosecution has been used for different purposes, and the whole divestment thing is in the back burner, because there was a clear agreement that you'll have right of first refusal and the balance stake is supposed to be purchased. So I think if we really want to attract investment, and if the government needs to, our prime minister has, I think, spoken about a 5 trillion economy, that is not going to happen unless we really make it attractive. There have been very good examples also. I'll share a good example of previous company, HCL, who was invited, none by the chief minister, to put up a project in Lucknow, and it was discussed at the highest level, at the chief minister and the chief secretary level, and everything was done in means there was no any demand. And I think I'm privy to that entire project. So the point is, if you really want to attract investment, you have to, first you have to decriminalize the laws, and you have to really, in terms of whatever discretion is there, in terms of approval, license, permits, unless those are simplified, those are made transparent. I remember, I'll give you another example. As a student, I used to study in University of Allahabad, and my parents were near Calcutta, so I used to travel by train. And those days there was no IRCTC. You have to go and stand in the queue, fill a form, and ask for a reservation. The clerk will say, "Koi seat nahi hai." You pay him $50. He will say, "Let me try from the next station." So he gives you a confirmed ticket. So something which is a matter of right. Now today, because of IRCTC, you can log in, you can see the berths which is available, you can select the train. I'm just telling. So technology and IT and transparency has to be really brought in if we really want to address the issue of corruption. It should be more transparency, and I think government is working on it. Especially in mining sector, they are talking of of projects where it will have embedded clearance and approvals in wherever mineral auction is coming. But I think it is too slow, and I think it should be done on very immediate and urgent basis to achieve the 5 trillion economy.
Actually, the example you gave of Sterlite, Satyam, same thing happened with Mahindras after they took over. So, you go and try and do a good deed, really, the unfortunate situation right now is no good deed will also go unpunished in Indian business. So let me just.
And in fact, Pratibha, if I may just come in fact, I have a first-hand experience of handling an environment matter of this copper smelter in Tuticorin, where the plant was closed by the Madras High Court, and I appealed to the Supreme Court, got the SLP filed within a single day, got a stay order, and it was heard for 2 years, and we came out successful. There was a issue which was raised by one of the NGOs, is that this plant has they have filed a SLP saying they are operating with all necessary approvals and everything in place. So SLP should be dismissed because they don't have the consent to operate. So actually there is a deemed approval under the Water Act, but there is no deemed approval under the Air Act. And believe me, today you may have the approval till 31st March, but you don't have it on 1st April. What will you do? A plant, a steel plant, or a power plant, or a copper smelter, or aluminum smelter, or for that matter, a cement plant, will you close the next day? And who is going to gain by that if we strictly go by the law? Now, 100 crore fine was imposed by the Supreme Court on the ground that you operated the plant without valid approvals, not a single stricture against those officials who sat on those applications for consent to renewal. And those 100 crores, I don't want to go into that. That's still lying with the government. So I think, in terms of there's a lot to do. There's a lot to do in terms of processes of doing business, decriminalizing things, and the classical example of the Samsung chairman being prosecuted, and it's in itself a case study.
Absolutely. And, unfortunately, we are not having as many discussions on these issues that we should have, especially, the kind of corruption that this promotes. And this whole push towards making India a manufacturing hub, especially with, the environment against China. I think a whole further discussion needs to be done, especially with stalwarts like both of you, on how this affects manufacturing and what do we actually need to do to address that sector. Because and if I can have just because we are running out of time and I have a lot of questions from the audience also, but it's so important to understand why a country like India with so much young talent, all resources available, is not able to make itself a manufacturing hub. Manish.
Yeah, so some of the issues, Pratibha, which I
Manish, you're
touched
still on mute. Sorry, Rajiv. Go ahead.
are very, very relevant. I am telling you the ground situation because of the reasons of confidentiality and my company's communication policy. I can't give you specifics, but to run a physical industry, and I'm not talking about the local MLAs who say you have to give the contract to X person, Y person. If you don't give, I will create an IR issue. There will be an industrial unrest. They will attack you. They will, you have to deal with transporters, and the list is endless. I think it's really a pain in India. I am telling this you first-hand, information. It's pain in India to run a hardcore manufacturing. And remember, the entire service sector is based on manufacturing. Today, we are not doing well. The GDP is not doing well because manufacturing is all-time low. All-time low. No new project is coming. I was in Vedanta in the period 2005 to 2014, and somewhere in 2009, 10, 7, 8, 9, investment of 10,000, 20,000, 30,000 crore. This is the kind of project we used to discuss, and money has been invested. I am sure there are many such, and I would say with all respect, to some extent, I think judiciary has also been responsible for derailing the growth, cancelling everything and saying that everything should be auctioned. We will see how much things, what kind of, see the telecom sector today. there are there are no takers for 5G today. They are struggling to survive. So
Absolutely. And and when the
I
judgment
think
had come, I remember we was I had written a couple of articles against the judgment, and it wouldn't get published because there was such a public image also created that the judgments were right. Nobody thought about the economic aspect of it. Manish, you're still on mute. We can't hear you guys. Is it from our
Can
side?
can you can
Yes,
you hear
now we can
me?
hear you. Yes, yes.
Okay, so I'll give you. You're giving an example. So a lot of things are happening. A lot of things will happen. I'm sure we will get in. If you look at the mobile phones are getting manufactured in India. A lot of things are happening, but there are small things. Again, I will come back to a small legislation which I've been always harping about is the Legal Metrological Act. China problem started. This is a real life issue, and we have so many GC friends. I will not name the company. Those company, a large Japanese company was in at one end they were discussing that they must shift their manufacturing plant from China. The choice was between Indonesia and India. While these discussions were going on, a legal metrological department inspector inspected one of their godowns, and when one invoice was issued of television sets which said 32 inches invoice. The the television sets clearly and categorically stated in centimeters. On the basis of that invoice, that inspector wanted to confiscate the entire stock in the ground because on the bill, as it is written 32 inches, so 32 inches was written, he wanted his pound of flesh. That one small inspector and this one small legislation changed everything in favor of Indonesia.
absolutely,
So you may take it as a very small thing. Only 5,000 rupees fine is there. But look at the site. If you issue a notice to all the Japanese directors of that company, I'm privy to it, and I know for it. I'm not speaking. It's just the new, very recent experience which has happened. Acquiring land. Today, what has happened, like telecom, you feel that all the developers are cheats. That's not true. They are good developers. And what has happened, if nothing is going to happen insofar as our country is concerned, insofar as the hard infrastructure is concerned, today to acquire land, is it easy? The answer is no. How do you acquire land? How do you get the permissions? How do you get the consent to operate? After getting the consent to operate, how do you get the CC, OC, and then you get the factory license, and then you put up the factory? Manufactured goods in the godown, you go and issue a notice to every one of them. So this is not, we have to be welcoming. Let us take, for instance, what happened in so far as after this lockdown has opened. Some person sitting in some corner came up with a very bright idea that if something happens to an employee, then the employer will be punished. You would have seen, and then the government had to clarify that no, we will not send you to jail. So how will that entire process start? So the government is absolutely well-meaning insofar as what it has done. And let me tell you the good part of the government. Let me not be only criticizing. I am one of the greatest supporter of the reforms which have been brought in. 10 years down the line, people when I will be about to retire, you will see that the kind of changes which come in this pandemic, the agricultural sector, the Essential Commodities Act, the Market Committee, the manner of which the reforms have come, the GST, the IBC. 10 years down the line, we will remember it similarly as we have remembered 1991 insofar as these reforms are concerned. So a lot of positive activities are concerned, but at the ground level, sentiments in these small and like the Stamp Act in Bombay, if you do not register a license agreement which is more than for a 6 months, you can go to a jail. Why do you want to send everybody to jail for these small? Why don't you put that stamp duty is not paid? I understand. I have not examined that act for some time, but it says that under the Rent Control Act, if a license is for a period exceeding 6 months and you don't register it, this law is only in Bombay. Why do we want to send everybody to jail for trivial tittle tattle matters? as they did insofar as the labor legislations were concerned, which were neither benefiting the labor, nor the economy, nor the industrialists, except for few politicians and very few the trade union leaders. These have completely lost their relevance.
Absolutely.
Similarly, lock, stock, and barrel, where all economic legislation, where the offense is less than 2 years and it is not a moral turpitude or something to the bad to the society, it is a trivial little matter. With one stroke of pen, they must all be removed. All municipal corporations, all small fines on advertisements on dogs, cats, houses, throwing water, sanitization, not putting the mosquito people come and issue notices to all the companies, lock, stock, and barrel. All these enactments where the businessman is to be put to jail, where it is for less than 2 years, no purpose will be served. Just remove those criminalities completely, and then see what will happen. The large offenses is one you must go forward to. If your today the situation is bad, today your IBC goes, 138 goes, what kind of a havoc will be created in the credit system? So we need to decriminalize not 1 to 18. I'm told that the last count, there are over 25,000 legislations and subordinate legislations. Remove criminality, lock, stock, and barrel, and then see, insofar as if the fraud has taken place, if something has happened to the society and things of that nature, or a very large thing has happened, then you pick and choose and say that here it would be. Because when FEMA, as I gave you an example, when FERA became FEMA, at that point of time when the FERA was there, we had to mortgage our gold in order to get the foreign exchange. It would not have lasted for a month. Today we are sitting on $500 billion with the kind of deficit which we run. We are good for 1 year or maybe more. So therefore, all criminality, if FERA can become FEMA, I'm sure the municipal corporation can also change. The stamp authorities can also change. And there has to be a proportionality. Again, on stamp duty, myself have suffered a notice, so therefore I'll give you an example. It says fine up to 10 times. Assuming I execute an agreement and I do not pay 1 lakh rupees of stamp duty, immediately it will become 10 lakh rupees. So there is no proportionality. So that it should be decriminalized immediately. And these 10 times penalty would be 18% interest for the period for which you have not paid. Because the discretion has been provided from 1 to 10 times. You understand, when you provide this kind of a discretion in the statute, what happens? So wherever this complete discretion has been provided, must go, there must be method to the madness. Once you do that, you decriminalize. As I was telling you, the anecdote was that this may be our 1991 moment. As I was recounting the story to you, what happened was that, as I told you, how FEMA became FERA became FEMA. There was an economics professor who was to go to Paris, a fully funded program by UGC, but the per dime rate was $65 per day. He knew Manmohan Singh, who was the finance minister at that point of time, wrote him a letter to him stating that how do you assume that somebody would survive with $65 in Paris? He sent it to the joint secretary, and joint secretary said that why should the benefit only given to one individual? Why don't we examine the particular section? He wrote that note and sent it back to the chief economic advisor. Chief economic advisor wrote a note on that file stating that why don't we look at the entire FERA Act? With this note, it was sent to Manmohan Singh, who was then the finance minister. He wrote, why only FERA? Why don't we look at all economic legislations? So I think, and that is how the entire liberalization took place. And this is a story which is quoted in open. Similarly, this may be an opportunity. This list of 19 can become 19,000 whenever this kind of a criminal for trivial tattle matters. And the first 2 pages of this notification are important. That should be taken as a cue. and wholesale lock, stock and barrel criminality should be removed.
So Manish, let's take I'll take a pledge with you. Ours can be the next letter which can help bring the next revolution for easing of some of these criminal offences. If you work with us, we will put in that representation to the government, because I think it's absolutely
pro bono law clerk. I can work under you, ma'am.
No, it's the opposite way I was suggesting. We are already 8 minutes over time. I'm going to request the organizers to give us a few minutes more. Prashant, just very quickly, one question is, can these be applied? Since they've already said they're going to apply all laws prospectively, would these be applied prospectively or retrospectively?
Sure, Pratibha. Thanks for that question. So, I mean, given the paucity of time, I'll just try and make it quick. So, the reason why it is relevant to discuss this topic at this point as to whether these laws would be applied prospectively or retrospectively is because of the objective that this consultation paper sets out, which is one, to ease the process of doing business in India, which consequently would attract sort of more investments. And second is to unclog the pending litigation which is there in front of a lot of courts. Now, keeping these objectives in mind, one, of course, the ease of business would not only be with respect to new businesses coming in, but also with respect to the existing businesses. Now, when you apply this law prospectively, then what the message that it gives out is that everything that has been done so far will remain as it is, and therefore it will continue creating trouble for the businesses that have already suffered from it. Whereas if you intend to apply it retrospectively, that is where, I mean, we feel that the intention may be achieved. However, when you do that, there has to be certain checks and balances that need to be kept in mind, which could be in terms of what is it, this damage that we are talking about? Is it of a repairable nature? Is it of an irreparable nature? And then keeping all of those nuances in mind is how a decision can be taken upon whether it can be applied on a prospective or on a retrospective basis. Now, under common circumstances, you generally go for the prospective route. If that is to be proposed, then what needs to be kept in mind is that there has to be a sunset clause built in the regulation that could sort of provide a bandwidth with respect to those cause of actions that may have occurred before the regulation coming in, and the time when the authorities take cognizance of it. So that window could, I mean, while in case of FERA and FEMA, it was a 2-year long window, in this case, it could be kept considerably short so that the objectives can ultimately be achieved. So keeping that in mind, I mean, while the most optimistic route here would be to go the retrospective route, but if prospective is to be taken, then certain nuances need to be kept in mind for that as well.
Wonderful, thank you. I'm getting a lot of comments in the Q&A session saying, how superb the session is, which I'm obviously not surprised, and agreeing with most of the views that have been provided by you today, and some suggestions also, but some questions on, for example, the safety rules that have been provided by the government under the due to the pandemic. Again, there's personal prosecution that can happen under those for the employers. So a view on that. Does a pandemic justify criminality of such provisions? Manish, you're on mute.
I think I can take that. The government had issued a notification, a clarification, Ministry of Home Affairs, that although there is a provision of criminal action, but what will be seen is that you are completely negligent. It's only in such a case because the way we read, in fact, most of my head of operation for the cement plant, they told, sir, if this is the situation, I don't want to open my plant. And then we had to kind of speak to them and make them understand that the kind of SOPs which we have if you follow, it is even beyond what government has prescribed. So I think the intent will be seen, and although there is a provision which is a kind of deterrence for people who do not follow, I don't think the government on the issue of pandemic, now I think the lot of water has flown, and people have understood what's the intent of the government is to basically ensure that the pandemic doesn't spread in terms of social distancing or maintaining hygiene and everything. So in my view, there will be very less prosecution, or there will be minimal prosecution.
Thanks, Rajiv. I think we are already quite over time, so apologies if I have not been able to take some questions. But thank you so much for giving us your valuable time to discuss this important topic. As I mentioned, we will try and put in some recommendations to the request by the government, especially Ministry of Finance. So to the extent that even the audience has anything that they think should be included, which has not been included, like our panelists today said, there are probably hundreds of such provisions out there. We'd be happy to take those recommendations and include it in the list to be sent to the government. On that note, thank you once again, and we hope to keep these discussions going forward. Garrett, over to you.
Thank you, Pratibha. Thank you, Manish, and thank you.
Thank you, Rajiv. Thank you, Pratibha.
It was a pleasure.
Thanks,
Just
Prashant.
wanted to thank you all. It was wonderful. I've been on the Webex right from the beginning, and it was wonderful, very interesting discussion. Thank you really very much. And I remember first time you talked about FEMA, and in 1983 when I wrote a book on that subject, I had quoted IMF Article 4 and 8, in which India was obligated to move to current account convertibility. And I had opposed FERA at that point of time, which was, considered to be a little awkward. Nobody would criticize FERA so much. But in my book, in the first chapter, and it was nice to see over a period of time there was some movement, but we are waiting for further movement from now 1990 to about 20-30 years. I think we have to move towards capital account convertibility and other kind of situations which can make us global players. But hopefully we get a chance to interact with each other more. And I wanted to thank you so much. Grateful to you, Rajiv, and Manish, and all of you. It was very interesting discussion. I really enjoyed it thoroughly. And I think it's very useful. I think this is a subject which has not been discussed enough, and we should all be taking up a little more seriously, because all of us are talking about. I think this evening, I'm sorry to be extending a little bit, taking with your permission, I will take women's
Absolutely,
permission.
Nishith.
It's absolutely a pleasure.
And I was on a major call on supply chain breaking up from China, and everybody has been talking. India has a great opportunity, and all those things. But the thing is, I've been able to capture the opportunity because and what the studies I discussed a lot with the consulting firms around the world, and what came out that if there are 100 companies to be migrated from China, almost 50 may still go back to US, and another 50, of which about 40, 45 will go to Vietnam is doing very well, Cambodia is doing very well, even some other countries, including Bangladesh, is doing better. I think we are stuck somewhere that even if tomorrow we have to bring plant from China to India, I think it's not very easy. Unfortunately, we all would love to do that. So next week, actually, we are having 2 sessions that make in India via Southeast Asia. So we say as Indian companies, we have stopped neighboring countries to invest in India, but nothing stops us from going there. So we are trying to explore a strategy where can we acquire facilities from China, move them to Cambodia or Vietnam for some point of time when the Indian situation improves, and then bring them to India once the and hopefully if you're there, and maybe we'll send you some information, I think, on the cCep. So we are exploring the strategy so that the supply chain, we can be part of it. Otherwise, I think we'll almost lose out. We have so much opportunity on using the supply chain breakup that is people have been talking about it a lot. And everybody said India is a great opportunity, great opportunity, great opportunity. 3 months, nothing else. But I think we are still not ready. That's what appears. I'm a professional. I'm not a businessman like you, so I don't understand too much. But my gut feel is that if we are a little away, let us admit that it's going to take still 3 years. Okay, but that should not make us lose the opportunity that exists in the interim and get them to elsewhere. And we still own those facilities. We migrate them. We can supply technology, manager, personnel, many other kind of stuff from India to those the intermediate jurisdictions, and then see how it unfolds. And in the meanwhile, we have to really focus on services as well. But I think these are interesting talks and discussions. I'm really grateful to you, both of you, and everybody on the panel for this scintillating discussion. Let's stay connected, and thanks a lot.